Everyone is in, but we will go ahead and get going. Good morning and welcome to Providing Pro Bono Services to Nonprofits 201, Learning from the Experts. My name is Robyn Miller. I am with Senior Corporate and Tax Counsel with Pro Bono Partnership of Atlanta, and I'm your moderator for today. Before I get into any details, I have a few announcements. I need to say that this is being presented in conjunction with the Atlanta Bar Tax Section, who generously assists Pro Bono Partnership every year and is a supporter of our activities. And Richard Litwin is on the board with me of that section. So it's an honor to be a part and connected with the tax section. And if you are a tax attorney, I highly recommend that you consider joining the Atlanta Bar Tax Section and all of its offerings. In addition, I think you all may have heard that this is being recorded, but if you didn't, the announcement has been made. CLE will automatically be submitted to the State Bar today, so you need not provide any codes or fill out any forms. Because this is being done through the Atlanta Bar, and Tanya Wyndham, who's amazing and has coordinated all these pro bono March Madness events, has taken care of all of that for us. The last announcement is please use the Q&A today for all questions. In order to keep our panelists moving and talking, we will be monitoring the Q&A and asking the questions on your behalf. And sometimes we'll provide answers in the Q&A and sometimes we'll provide them live. So with that, a little bit about myself. Like I said, I'm Senior Corporate and Tax Counsel with Pro Bono Partnership of Atlanta. I've been advising nonprofits for over 30 years. On tax and corporate issues in various capacities, both in Ernst & Young and at several law firms. And I've been with Pro Bono Partnership of Atlanta for almost 14 years. You'll hear me refer to Pro Bono Partnership of Atlanta as Pbpa throughout this presentation. So you'll know a little bit about when I say that, what that means. All right. And I'd like to start with sharing a little bit more about Pro Bono Partnership of Atlanta. So we provide free legal assistance to community-based nonprofits that serve low-income or disadvantaged individuals. And we do that by matching those organizations with volunteer attorneys from leading corporations and law firms who can assist nonprofits with their business law matters. And I'm excited to say that all of our panels today are some of our rock star volunteers. And that's why they're here, because they're going to share their experiences with working with our clients and how to do it really well, because they're some of our best. And so we appreciate them. A little bit more about Pro Bono Partnership of Atlanta. We've been around 17 years. We have served over 1,050 clients in that time period. And once you're a client, you're pretty much always a client. You come back, we have 5 attorneys on staff, and each of us act as outside general counsel to our clients. So our clients can reach out anytime to their outside counsel, on staff and say, I've got this issue. And then we try to find a wonderful volunteer attorney to assist. We have over 3,000 volunteer attorneys that help us, but we are always looking for more volunteer attorneys. And I'll tell you a little bit more about that in a moment. A little bit about our clients. So to be a client, you have to be an existing 501c3 nonprofit. You have to serve or be located in the greater Atlanta area. You need to serve low-income or disadvantaged individuals, and we consider animals to be disadvantaged individuals in many cases. So we do take on pet rescue groups and shelters and things of that nature for pets. And you also have to be unable to afford legal services. So if it would impair the client's ability to do their work in the community, then we consider them viable for a client. Like I said, we are always looking for volunteers. If you are not currently volunteering with us and after this presentation are interested, you can go to our website, which is actually listed right here on this slide, and you can go to, there's a tab for volunteers, And we have FAQs there, and you can read all about what it means to volunteer and how easy it is. You can also simply email to info@pbpatl.org to sign up to volunteer with us. You'll get our monthly, actually twice a month, email that includes all of our matters. But those matters, we call them volunteer opportunities or VOLOPs. Those are always listed on our webpage. So lots of our volunteers, just when they have a minute and they're not that busy, they tend to go to our website and pick a project, and we get them matched and get that project started. I have one lawyer who's really interesting. He's like, I always take a matter when I'm super busy because I figure that by the time we're really getting rolling, I won't be as busy because it does take about a week or so to get a project underway. We always have an initial call, and it just takes a few minutes or a few days to kind of line everything up and get it moving. We also provide our volunteers with lots of forms, sample contracts, materials, so that you're not starting from scratch. And it will always say that on the volunteer opportunity if we have such a form. All right, and one more thing I want to mention about Pro Bono Partnership of Atlanta before I introduce our amazing panelists. We have a great resource on our website. It's our Learning Center, and in our Learning Center we have articles, workshops, webcasts, and podcasts information. You can go on, and we have a decade of webcasts that you can watch through our YouTube channel. And we have podcasts that we've been doing for a little over a year now, as well as articles on just about every subject that a nonprofit could face. So if you're just on the board of a nonprofit, you can always go there. This is all free information. But if you're volunteering with us, sometimes we'll give you those resources to help you as you proceed. All right. So I am so excited to introduce these volunteers. This is my dream team panel, I have to say. They're the best of our volunteers, especially on these particular topics we're going to cover today. So I want to properly introduce them. First, I'd like to introduce Richard Litwin with Litwin Law. He specializes in state and local tax. He is really our sales tax guru for Pbpa. But he works on a variety of different things under state and local tax and tax disputes, including sales tax, use tax, multi-corporate income tax, personal income tax, state residency, local business tax. He's a fellow with the American College of Tax Counsel. He's like been a Georgia super lawyer forever. And he's part of the top 100 Georgia super lawyers, in fact. He's been identified by U.S. News and World Report as one of the best lawyers in America. He is also co-moderator of the Georgia Department of Revenue Attorney Liaison Committee, which is great because he knows everybody at the DOR, which is a really good relationship to have. He graduated from the University of South Carolina, and he graduated undergrad, and he graduated from Emory Law. And he proudly serves on the University of South Carolina Board of Visitors. So we're grateful to have Richard here today with us. Next, I want to introduce Gail Gunnells. Gail is Senior Outside Corporate Counsel at the Coca-Cola Company. Gail wears a lot of hats, and she has had many amazing positions. She has extensive experience providing complex legal services across multiple specialty areas for Fortune 500 companies. She has more information in her brain than about anybody I know in terms of different areas of the law. She handles not only Fortune 500 companies, but technology companies, advertising agencies, government, and nonprofits. So she's worked in all those various areas. She was general counsel for 2 separate software as service companies, one of them on the NASDAQ. She was deputy chief legal advisor to Georgia Tech, legal advisor to the Board of Regents for the University of Georgia System, and as well as the University of Georgia System Foundation. She was a partner and practice group leader at a big law firm, and she currently is marketing and sponsorship counsel at Coca-Cola. She graduated from Emory undergrad and the University of Georgia, both with a master's and her JD. Like I said, these folks are my dream team. They are so incredibly talented. Next, I want to introduce Mindy Simon. She is Associate General Counsel and Senior Tax and an International Specialist. Mindy has more than 20 years of experience working with tax-exempt organizations. As Associate General Counsel, she advises on a wide range of issues at Emory. She advises on a wide range of issues, including tax, executive compensation, conflict of interest, international, and general corporate matters. Before joining Emory, she was at Smith, Gambrell, and Russell in Atlanta, and there she specialized in federal tax and tax-exempt organizations. Previous to those positions, she served as staff assistant for U.S. Senator Jim Sasser, and she spent some time in Thailand teaching English, which I love about Mindy. She received her BA from Rhodes College and her JD from the University of Tennessee. Mindy was chair of the nonprofit law section of the Georgia Bar, and she was also president of the Atlanta chapter of the Georgia Association of Women Lawyers, and she speaks nationally. So we're grateful to have Mindy today. And last but certainly not least is Marian Tilson. Marion is Assistant Vice President and Senior Legal Counsel at AT&T. She practices in AT&T's legal department's contract center of expertise, and that is like the perfect place for her because of her contract expertise. We lean on her often for that, as you'll hear more about. She supports AT&T's global supply chain, specializing in technology transactions and implementing AT&T's technology migration to the cloud. She has a practice background in wireless operations, environmental law, and litigation, so she covers it all. She's also a graduate of the University of Tennessee Law School, and she was honored last year by AT&T as its National Pro Bono Volunteer of the Year. So we are so excited to have this group. I hope you will find this to be a really dynamic discussion. But before we get to that, I need to spend a little bit of time talking about professionalism. So I wanted to introduce our panelists, but we got to spend a few minutes talking about professionalism, so that you get that wonderful 2 hours of professionalism credit today. So this presentation falls under what's called Rule 7, which is a fairly new rule for professionalism. And what it allows is for professionalism credit is permitted for training in substantive law that's specifically designed to enable lawyers to engage in pro bono representation that you wouldn't otherwise be competent to provide. So our goal here today is to give you all kinds of great tips and understanding and things to think about when you're representing our clients that maybe you don't have that experience in your day-to-day practice. And so we need to tell you that and you need to agree that that's what you're learning today. And that's part of the rule. And frankly, for us at Pro Bono Partnership of Atlanta, we're so excited to present this because we're always in need of more volunteers. So hopefully you'll learn a lot from this. You'll be really excited and you'll go to our website and take on some matters. All right, so there's 2 items we need to cover when it comes to professionalism. The first is the lawyer's creed, and the second is the aspirational statements. We're just going to cover the general aspirational statements. Honestly, I think it's always a good idea to refresh on these things each year. They apply not only to our daily work, but also to our pro bono work. And it's just a really good reminder of being a lawyer and what it means and what we're committed to doing as human beings, as lawyers. So I like to point out a few of these that are particularly relevant to today's presentation. To my clients, I offer faithfulness, competence, diligence, and good judgment. I will strive to represent you as I would want to be represented and be worthy of your trust. I've been so impressed with our volunteers and how much they put our clients first on their list or just as high up as their paid clients, and really try to do the very best work they can possible for them. And that's just right in line with this part of the lawyer's creed. To my colleagues in the practice of law, I offer concern for your welfare, and I strive to make our association a professional friendship. A number of our volunteers work together, and it's not just one attorney working on a project, but sometimes several. And as you'll see in our hypotheticals today, there are times where a client might have an issue that involves multiple different areas of the law and different attorneys, and they have to collaborate. And so I think this fits in really nicely with that concept. To the profession, I offer assistance. I strive to keep our business a profession and our profession a calling in the spirit of public service. And that's what y'all are here to do today, is to learn more about public service. To the public and our system of justice, I offer service. I strive to improve the law in our legal system and to make the law in our legal system available to all, and to seek the common good through the representation of my clients. So again, this is directly in line with providing pro bono services, and it's what we're all about. So, and I want to say that when you help our clients are busy lifting up our community. They're serving those in need in our community. And so when you help them, you're really helping to lift up those clients as well. And you're really helping to strengthen the community around us. All right, let's now turn to those aspirational statements, the general ones. And there's a few here that I want to highlight. And these are, as a lawyer, I will aspire. So put that in context. To put fidelity to clients and through clients to the common good before selfish interests. Again, taking on those clients' interests and putting them first. And that's really important with our clients, and we appreciate our volunteers doing that. To avoid all forms of wrongful discrimination in all of my activities, including discrimination on the basis of race, religion, sex, age, handicap, veteran status, or national origin. The social goals of equality and fairness will be personal goals to me. Many of our clients are working to address discrimination in our community and to help those who have been victims of discrimination to improve their circumstances. And so when you help our clients, you're often helping to reduce discrimination and provide equity and fairness in our community. To preserve and improve the law, the legal system, and other dispute resolution processes as instruments for the common good. Again, by assisting us, you're helping to do that, and to make that legal system available to more people in need and organizations in need. All right, one more slide on professionalism, and these all kind of echo, and you kind of hear the same themes running through them. So I'm going to just highlight a few more of these, which is to make the law and legal system and other dispute resolution processes available to all. I've already covered that. To preserve the dignity and integrity of our profession by my conduct. The dignity and integrity of our profession is an inheritance that must be maintained by successive generation of lawyers. One of the things I love is how we have so many, first and second year lawyers that want to volunteer with us. And I think that is really impressive that, not only are they going to get substantive experience, but they really care about our clients and really help them. So thank you. And thank you all for being here and learning more about how you can help nonprofits and do pro bono work. To achieve excellence in our craft, especially those that permit me to be the moral voice of our clients to the public in advocacy while being the moral voice of the public to clients in counseling. To practice the law not as a business, but as a calling in the spirit of public service. So I love the fact that all of this ties into all of the work that we do at Pbpa. All right, now I'm actually not going to go to this hypothetical. I am going to, stop sharing and show you our panelists. All right. So today's presentation it's designed to really be a panel discussion. And we're going to talk about a variety of different areas that our clients tend to have issues with. And then we've got a series of hypotheticals that I'm going to ask our panelists to talk through and provide their advice on. So I will tell you that most of these hypotheticals come from real experiences with our clients. Some of them have been tailored a little bit more to put things together in one hypothetical, but these are all real world issues that we have seen with our clients. So I'm going to begin by asking questions to Marian and Gail on contract drafting when helping small nonprofits. Marian, you've worked on so many contract matters with our clients. In fact, you're up to 50. She's done 50 contract matters for our clients over the years. What do you consider to be best practices when drafting and reviewing contracts for a Pbpa client? We can't hear you.
Robyn, thanks for the chance to talk about this, something I really have enjoyed. I've probably done so many contracts because I've been doing this so long, but I just think the Pro Bono Partnership provides a great service to nonprofits, and I'm glad to give you a little plug, but I really enjoy that work. You and your colleagues do a great job of describing the opportunity, so I know what I'm signing up for. And then even if the client tries to expand the scope beyond what I signed up for, you don't let that happen. And so it really helps manage the project, and I'm able to fit it into my daily work. So I really just think you guys do a great job of making it easy for attorneys like me to get back. So it's a super service. But as you said, most of the projects I do involve contracts, and those might be with, usually they're between two smallish nonprofits, and sometimes they're with a nonprofit and an individual or maybe a government. But I guess my guiding principle is to make sure I have a contract that both parties can understand using plain English. My goal is that they will actually read it and understand it, because it's a lot of times just to make sure that they each understand what their roles are, what they're doing, how the money flows, if any, and who's responsible for what. So I certainly want the other party to be able to read it and understand it without having to feel like they need to retain their own counsel, because that would sort of defeat the purpose. So I draft the contract, and I'll go back over it. I'll check the words. Is there an easier way to say this? Is there a shorter way to say this? Even with customary limitation of liability provisions or indemnity clauses, I don't pick one up from one of, say, AT&T standard templates. I shorten it, I simplify it so they can really understand. Take out all the legalese, the hereafters, and the whereases, and just use very simple language. I break up paragraphs, I number the paragraphs, I add white space, I use a regular size font, not small print. I mean, I really just want to make an easy to read and non-threatening agreement. And the clients really seem to appreciate that, that I strip it to the basics. I'm like, oh, maybe we need this or this or this. And I might be able to address a risk with one sentence instead of an entire section or paragraph. Anyway, again, just trying to make sure that the parties read it and get it and understand who's responsible. And one of the differences in working with these clients as opposed to a commercial agreement is that I try to stand in the shoes of the other party more than I otherwise would. I try to make a very fair and balanced agreement, including a risk allocation. I put myself in the shoes of the other nonprofit, think about what they may be concerned about, what are their risks, and go ahead and try to address those risks fairly, looking at it from both sides. And of course, issue spotting is important. This is a new client, you don't fully understand their business, and they may not have a full sense of what's going on with the relationship. But in the intake call, I usually, I'll know what this is going to be, maybe professional services or web hosting, or maybe we're purchasing something, or so I'll try to find a contract template on hand, maybe a professional services agreement, just to have on hand during the call. And so during the call, I might just be paging through that contract to think, oh, okay, maybe let's talk about invoicing. Let's talk about payment terms. Do we need background checks? What's our termination rights? And just make sure that I ask questions on those, general contract areas. And I've just found that using a long template is a way to do that. The ultimate contract I end up with will not look anything like the template, like a full AT&T commercial template, but it's just a good list to use to think through to make sure I ask those questions. And the issues can, run the gamut. They're very similar to a commercial agreement. For instance, confidentiality. These companies don't seem to be too concerned usually about their confidential strategic information or secrets, but they often do handle personal information, and so protecting the information of others is important. So that's one thing that is going to pop up in many of these agreements, and if they provide some kind of health services, of course, privacy laws and HIPAA and such. So anyway, the issues could be just about anything, but that template might help.
Yeah. Well, along those lines, like I said before, we often have sample agreements that we provide for our volunteers. And you alluded to something really important, which is that initial call. So for each matter that we always have an initial call. And on that call, the Pbpa outside general counsel attorney will do introductions. So we'll introduce the lawyer, we'll introduce the client, talk a little bit about the mission, and then we'll help sort of facilitate that understanding of that 1 hour call of what the project is, what needs to get done. And a lot of times, a lot of the information is shared at that time. And then after that, the volunteer attorney and the client work without the Pbpa attorney and get the project done, but we're available as necessary. I just wanted to throw that in there. Gail, what are your thoughts? You've worked on over 35 contract matters for us. What do you consider best practices when drafting and reviewing a contract for a Pbpa client?
I would just emphasize what Marian alluded to, which is you need to keep it simple. I find oftentimes, as Robyn has been on some of these calls with me, the initial call, I come away with my head spinning with everything they've dumped in our lap, because clients don't tend to know what's important or what's not important, and from a legal perspective for their issue. So they just tell you everything, or on the alternative, they don't tell you enough. And so as you start to get into it, you start to realize, wait a minute, there's more here than meets the eye, and they have this problem they don't even know they have, or they've got so many things out here, but the problem is really actually just the small piece of information that they thought was just a throwaway, and that's really the crux of the issue here. And so a lot of it is just almost like a common sense thing. It's not from the initial call, it's almost less of a legal issue spotting as much as it is just taking your common sense and figuring out what's important here. Like, what are they really trying to do? And so towards the thing of keeping it simple, sometimes they'll come and they have no contract, they have no anything, they just have a lot of questions and they know what they're trying, the end goal. Sometimes they come and they have a contract, they present it to you and you look at it and you're like, this has nothing to do with what they told me they're trying to accomplish. So it then becomes almost more of a people management issue, for lack of a better term, in terms of like setting expectations. Oh, this is an interesting contract. I think I have something that we're going to tweak it a bit. And so to Marian's point, you make it so like it's not a totally foreign look. You kind of use the same format and the font and maybe some of the same terminology, but you beef it up legally to make it binding or to make it not binding if that's the goal. We just want to have a little memorandum of understanding that just says, we'll all agree to agree. Okay, that's fine. That might be what they need, but it might not be what they need. And so a lot of it is just trying to figure out what their end goal is and how to best get them there. I find in my particular practice area, so many people, even lawyers sometimes, they're like, oh, we need a copyright, or we need a trademark, or we need, and they're intermixing the two. And so a lot of it is just kind of basic, and that's where Robyn's forums can, and webinars and other materials can come into play to help appreciate that, you know, most clients don't understand. You don't have to go register your copyright to get a copyright. Like, you have copyright from the minute this materials are created. And I've dealt with some in the education arena where they've got course curriculum and they're trying to protect. I had one recently that had that issue. And that led into some other issues that they hadn't really thought about. And I was like, I need to see all of your agreements where you got all of this grant funding, because grant funding from the government, that's going to impact who owns the ownership, who owns the intellectual property in that, and whether you can actually then turn around and license it yourself, even though you've been teaching these courses for years. Where did your funding come from? And you need to kind of dig back. So there's a lot of things like that that people don't really think about. And Pbpa has got a lot of wonderful resources to help. And to Robyn's earlier point, if you get into it and there's an area of expertise that's not yours, they can help bring somebody else in who is, to just answer a one-off question here or there. Just like any other case that you might work on, it might be, hey, I've got expertise in this and I can handle this, but now there's this tax issue that maybe we need somebody like Richard to come weigh in on and get that question, you know, off the table. And then also things like photo releases and liability releases, as they, you know, come forward with all the concerns they're working with. They may not appreciate, you just can't take these photos and put them on your website until somebody said it's okay for you to use their image in that way. And something very simple like that, of course, Pbpa is going to have forms for, but that's a lot of the kind of information that you just get into as you delve into their question. But a lot of it is less legal work per se and more kind of common sense. Let's take these and put them in buckets and then address it from there as to what we have forms for, what we don't, that kind of thing.
That's really helpful information. Thanks, Gail. So I have another question sort of for both of you. And what are your suggestions for how best to work with both the client, work best with the client, including setting expectations, communication and timing, and really anything else that you wish to share, and sort of that working directly with the client and managing them, because they're not AT&T and they're not the Coca-Cola company. Marian?
Well, Robyn, we talked before about this intake call, and that is really key to me with my projects. It's really the best time to get the attention of your client. These clients, these smaller nonprofit clients, they are busy. They are out doing good work, and this, you know, getting their contract or legal issue in order is not always their top priority, really. So, I mean, they know it's important, but they're out, you know, fundraising or whatever. So they're spread really thinly. But on the intake call, they've usually set aside an hour, and it's the best time to get their undivided attention and really get a sense of what's going on. So I like to get them talking about it, about the anticipated relationship. The more they talk, the more they learn. And of course, you have to guide them, as Gail was mentioning, to what is developing to be the actual important issue. They can go way off on tangents, but get them talking, because that's how you're going to learn things. And I've also found that I can make better use of that time myself if I spend a little time beforehand looking at their website, look at their story, what's their mission, you know, what is their, you know, what's their look and feel, what other things have they done, read the story of the founder, which is usually fascinating. And the same for the other, if there's another nonprofit involved with the transaction, look them up and see what they do. How sophisticated are they? Do they, for instance, have a privacy policy posted on their website? Just get a look and feel of who you're dealing with. And as with any, say, contract relationship, talk to them about what happens when the relationship ends. That's one of the most important legal issues of getting into a relationship, is how are we going to get out of this thing? What happens if we unwind? What happens if we exit? And then one thing I find is that Gail was mentioning sometimes they bring a contract to you here, this is what we're using, and it doesn't fit. But it's just as often they've come and say, we've been doing this for 2 years and we don't have a contract for it. So then it's a little bit easier at that point, because with those relationships, they sort of know what's going on. It's not new, and they say, this is what's been happening. And so in those cases, I start digging deeper into how does it really work, and what's working and what has not worked. When have you had disputes? When have you not had an agreement or meeting the minds? So that helps to get the history on those things.
That's great. That's really good advice about how to work with our clients. I appreciate that. And it's kind of amusing to me because you forget as I'm on these calls all day long. And so it's interesting to hear it from the perspective of the volunteer. Gail, what are your thoughts?
I would just add that, and Marion and I have talked about this in the preparation for all of this today. You have to keep in mind that some of these clients, when they get that first draft from you, they're like, oh, good. And they want to run with it. So if you have open questions or you have things that you need their input on before you can finalize the draft, you need to put it in a comment bullet or yellow highlight it, or make it so that they cannot use it without it looking like they're using something that shouldn't be used. Because if you just put it in there and like a little bracket and say like, hey, and be sure to fill this in, that thing's going to go out, that bracket will never get completed. And they're now using this weird form that somebody on the other side will be like, well, there was supposed to be a dollar figure in here, but it just says insert dollar figure, but they're so excited often to get a form. So if you've got things, I am a big fan of yellow highlighting in contracts that are not ready for prime time, because then at least somebody might go, oh, wait, there's something missing here. And comment bullets, anything that makes it just so that it's obvious that this was a draft. Because oftentimes that you do need to follow up, and you do need some input from them that after you've thought through it and kind of to the point, especially if they didn't have a contract and you're pulling one together, there'll be some blanks in there that you need them to give some details on that they've actually probably never thought about before. And then on terms of just the actual work itself, I like the guy who says that you said, Robyn, who he signs up when he's busy, because by the time it gets figured out, he might not be busy anymore. I like to always tell everybody, I need about a week to look at this and then get back to you. And usually knowing full well it's not going to take me a week, but those rare occasions that it does take a week, we all have days when my next 3 days are totally empty, and then all of a sudden something happens and they're booked and there's nothing you can do about it. And so you've kind of bought yourself some time at that. And they're always, even when I say I need a week, they're always like, oh, that sounds great and thank you. And they're very appreciative, because to a week to most people doesn't sound that bad when they've been, to Marion's earlier point, living for 2 years without a contract. It's like, oh, they're going to give me something in a week. That's wonderful. But then if you can undercommit and over deliver, it's good for everybody. But that'd be what I would add.
A couple things I think both of you do that I think is really helpful is, one, you do the work like right away. And honestly, that's best when the information is fresh in your mind, because it's not what you normally do. And so you got to kind of stay with it. So I find that our volunteers that take on the project and then really in the next week get it all down and are taking notes during the call and then work on it right away have the best success in completion, and meet the client's needs sooner, and not have to go back and forth as much. I also think that another thing both of you do is that instead of just sending a draft, you schedule a call. And you say, all right, I'm going to send you this, but let's have a call to discuss it, to go over those issues, because you don't want them running off and using the draft, which does happen quite a bit. In addition, when they get their final version, sometimes you never hear from them. And we keep trying to tell them, let your lawyer know it's finished and thank them. And they're very grateful. They always are more than willing to thank you. But they're, like Marian said, they're busy moving so fast that they just gonna take it and run. So those are really, really good points. All right, so now I'm going to share my screen and put up that first hypothetical. Give me 1 second, if y'all be patient. I've got to get to the spot where I can do that. There we go. Oh, that's hypothetical 2. We're supposed to be on hypothetical 1. All right. So now we're going to turn to our first hypothetical. Your client is, and I have the Q&A up, so I'm gonna reduce that. All right, so your client is Providing Hope, a 501c3 charity that helps homeless families. The Jones family hosts a charity baseball tournament every spring at a park in Cobb County. The Joneses' goal is to have 16 teams participate and to charge each team a fee to participate, as well as charging admission to watch the games. The Joneses pay all the costs associated with the tournament, the rental of the baseball fields, the umpires, the insurance, the advertising, etc. And then the net proceeds from the tournament are to be given to Providing Hope. The Jones family advertises the tournament in this brochure that they put out. And that brochure says that the charity baseball tournament is put on with Providing Hope, and it uses Providing Hope's logo. In addition, the Jones family also hires a couple food trucks to provide food, and they convince these food trucks to give 15% of their proceeds from the sale to Providing Hope. Now, about 3 months after the tournament, after all the bills have been paid, the Jones family simply plans to mail one check to Providing Hope from the tournament proceeds. So this is our first hypothetical. And so I go back to Marion and Gail, who are talking about contracts, and say to them, you know, what contracts are needed, what goes in them, and Gail, are there any specific nonprofit issues? So I'll start with Marion.
Thanks, Robyn. Well, the hypothetical seems to call for a contract between Providing Hope and Jones family, and maybe with the food trucks, and because particularly if the brochure says that contract's going to be put on with Providing Hope, it sounds like they're a sponsor, and I think with any sporting event there could be liability. So we need to sort through what kind of contracts we need. First of all, as to the Jones family, one of my first thoughts is, who's a Jones family, and who would Providing Hope even contract with? Is there a Mr. and Mrs. Jones that would sign individually? Is there a foundation? What's the deal here? So that's one of the first things to sort through. And then what about those food trucks? Anytime food is served, there's certainly issues there, and getting the money. So it sounds like the Joneses have set that up, but if Providing Hope's getting the money, do we need a contract with them as well? So those are some things to start drilling down into. I will need to think about what are the risks to Providing Hope? What are their issues from liability exposure? One is that from the tournament itself, there could be personal injury or property damage to those playing in the tournament, to those watching the tournament. There could be property damage to the facility, to something with Cobb County. And does Cobb County require permits or licenses or alcoholic beverage served? And who's responsible for getting all those things? And I would think it would be the Jones family, but what if they don't do it? Is Providing Hope have exposure there? So we need to address those things, those issues. And with the food trucks, likewise, do they need permits? Who's getting those? Are food safety inspectors likely to show up on premises? And as they do, I've been involved with where the safety inspector shows up and checks the temperature of the food. So we need to make sure that those things are covered. And again, personal injury, property damages by the food truck or to the food truck. So the list starts growing. So there's definitely risk, and so in addition to addressing those in a contract of risk shifting and who's a responsible party, we need to think about how to set this thing up so that we can mitigate the risk to Providing Hope. And I think the primary way is to be clear about delineating Providing Hope's role in the tournament as simply a recipient of funds. that they don't have any responsibility to put on the event. So that use of language really needs to change, and we need to shift the scope to they are providing hope is simply a recipient of the funding. I think a contract would want to cover that Providing Hope has the right to review any of the publicity for the tournament, social media posts, anything that refers to Providing Hope, and especially anything that uses its logo. We need to have clear language about proceeds from ticket sales go to Providing Hope and other language. We need to drill down on that and make sure it's very precise. We need to also clarify that what the Jones family is supposed to do. They've got to get the permit. They've got to get the licenses, whatever we decide with the food trucks. Do we need security for the event? Do we need traffic control, on site during the event, and make sure that they do that. If we're associated, if Providing Hope's name and logo are used, we want this to be a safely well-run event. It's a bit of a balance here, because here's a family that really wants to do something and to provide your client money, and we don't want to come down too hard, because we really want the money and we want to make it easy for them to do that. But on the other hand, that money can be wiped out if we have a liability issue. So the contract should just shift those things to the Jones in simple, I think, as simple, clean way as you can do it. And as in almost all of these contracts, look into insurance, because the Jones family may not have independent funds to cover any of these things. So need to think about insurance coverage and liability coverage that they have that would cover this event. So, beyond that, I want to find out, did the Jones family have any expectations for Providing Hope other than using the logo and receiving the money? So does the Jones family expect to be named on the website? Does Providing Hope have to speak to the media? Do we need to have releases for photographs, anything like that? Those are some of the first issues that come to mind about risk shifting, and then I'll turn it over to Gail to see if she has any other ideas, particularly about those food trucks.
Yeah, well, I'll be honest, my first thought in reading this was that if I was on the first call and this is what was presented to me, I would say, like, let's back up 2 steps. And this seems like an awful lot of work for the Jones family and Providing Hope, and an awful lot of liability for everybody to ultimately get some donations to Providing Hope. Are we sure everybody's in on this, and do we want to do this? Because surely there's a simpler way to raise some funds than to go through all of this. And my next thought is, once you, to do it properly, everything Marian just talked about needs to be addressed, plus some more things. And so when you ask whoever it's going to be from the Jones family to put their name on a dotted line on a contract, they may start having some second thoughts about whether this is something they really want to be, obligated contractually to do. So I would want to, but the next step, of course, is going to be where it says they've been hosting it every spring. And so this is probably something that's not going to go away. They want to continue it. They've probably got all these teams that are excited about participating. So when you get to the point, you're like, okay, this is going to happen. We just need to, need to make it happen like as best we can. Somebody described something to me one time about it will go unstated what it was, but there was a disaster legally that was going to go on. And it was kind of like this, where it's like a big mishmash of everything, but it's going to take place. So we need to just paper it over as best we can. And they go, the train is going to wreck. You just have to guide it to a softer landing. And so I think about that a lot of times when I see things that are very convoluted and complicated, like this scenario. This is going to happen. We just have to paper it the best we can to make it as less legally problematic, as can be. So a couple things come to mind other than what Marian mentioned. They want to just write a check at the end from the proceeds, and there's no accounting. So you need to address the accounting issue. And then the question about, is anyone that's participating on the Jones family side or the food trucks, Are they expecting to get a tax deductible donation or for some in-kind? I'm going to punt all that to somebody like Richard and say, like, we need a tax person. That's out of my wheelhouse. And then the second thing that comes to mind for me, some of the work I do right now at Coca-Cola is with regard to co-venture arrangements. These are national ones where we're partnering with a charity partner, like a Special Olympics or whatever. And you've seen them in the marketplace where we say, hey, if you buy this, making it up, you buy a 20-ounce Coca-Cola, we'll give a portion of the proceeds of the sales to the Special Olympics. Well, this food truck thing kind of is in that same wheelhouse, because they're saying, we're going to have these food trucks. You come purchase from the food trucks. They're going to get 15% of their proceeds from their sales. So a consumer of the food trucks is being incentivized to go buy food from the food trucks, because the food truck is going to give a portion of those proceeds to the charity. Well, that brings all kinds of other issues into play, because now you need a contract between the food trucks and the charity and letting them use the name. And then sometimes, depending on what state you're in, you need to register it and you have to disclose what you're doing, and then go back with the Secretary of State's office and filings and whatever. That doesn't necessarily apply to something like this in Georgia in terms of registration, because we're not a state that has that registration requirement. But it's something to think about, because there are state rules and regs all over the US that talk about transparency, making sure that, hey, if these food trucks say they're giving 15% of their proceeds to this charity, somebody needs to make sure that that's happening, and there need to be contracts in place to address that. Which kind of brings me then to all the tax issues that we'll turn over to Richard.
But before we do, though, let me just say a couple things. First, for anyone who's thinking about volunteering, don't let this scare you away, because you're always going to have a Pbpa attorney on who's going to help parcel through some of these issues and say, like Marian said earlier, look, this is a little beyond what Marion's doing. Let's let her work on this piece of it. And maybe we'll bring in Gail, or we'll find another volunteer to work on this co-venture agreement, which is the arrangement with the food trucks. So don't feel like suddenly this could explode into a variety of issues. The other thing I want to say is that, because I know this isn't Richard's area, he's going to talk about sales tax, but there are the issues involving income tax and whether you can take a deduction or not in these circumstances. And so if they're collecting all of that money and simply providing a check, then all those people that participated, first of all, they participated, so they got something of value. They watched the games, they had a team that participated, and so that's not a donation. So there's no donation receipt for that. So it doesn't look like they're really accepting donations and then giving them off to the charity, to Providing Hope. So there's really going to be no donation receipt here. And the Joneses, it's not really their money that they're donating either. They've just put this all on. So you wouldn't give them a donation receipt either. And with the food trucks, of course, people are buying food, and the organization is then donating from their sales through that co-venture arrangement. That's a separate issue to consider in the co-venture arrangement as to whether they're donating that money, which they likely are. So from their sales. And that can be covered in the co-venture arrangement as well, but you would give them a donation receipt for those sales. Mindy, anything to add to that before I move to Richard?
No, just that in the case of these types of charity tournaments, you'll often get sponsorships, and that would layer a totally different set of issues on it. And we'll talk about that in a later hypothetical.
Great. All right, Richard,
okay.
On to tax.
This is what I'll say as sort of a prefatory remark to the participants on this program. In the wake of the June 2020 bulletin issued by the Georgia Department of Revenue on fundraising and sales tax obligations of nonprofits, there is heightened scrutiny. So you can't just brush aside any of the sales tax issues and just say, oh, well, we're doing this for charity, or this is nonprofits. The Department of Revenue doesn't enforce sales tax on nonprofits. First of all, they're doing it now if they weren't doing it before. And second of all, I've had situations with Robyn where they are enforcing it. So it does happen. And then as far as the food trucks are concerned, I know we've ad nauseum talked about the food trucks. The only thing I care about is make sure the food trucks know to collect sales tax based on where they're located. Most of these food trucks outfits understand that where they're located in terms of what county they're in is the sales tax that they have to apply. Now, as far as this facility is concerned, the Cobb County baseball fields, they may charge sales tax for the fee that they would charge normally for anybody using the facility. Technically, sales tax doesn't apply to the rental of real estate, but this may be a charge for participation in amusement activities or entry fees, and those are subject to sales tax. So just as a precaution, the Jones family should first register with the Georgia Department of Revenue. They should register with the Georgia Department of Revenue and get a sales tax number, and then provide that sales tax number on a certificate called a Form ST5 exemption certificate, so that they are buying, or the facility charges are not subject to sales tax, because technically the Jones family is then re-renting the facility or re-renting the charges when they take the participation or entry fees from the tournament participants. And those entry fees are not subject to sales tax in this situation. They typically would be subject to sales tax. So just sort of step aside for a second. If there's a tournament down at the Georgia World Congress Center and every team has to pay $500 to participate in the tournament, that $500 is subject to sales tax. In this particular case, though, because the Jones family is charging admissions for people to watch, for spectators, and those admissions charges are going to be taxable, and the Jones family is going to collect sales tax on those admissions charges, there's a special rule set out in Policy Bulletin 2017-08. It states that the organization does not have to charge sales tax on the entry fees that each baseball team or softball pays, if the organization charges the spectators an admission fee and collects sales tax on the admission charges. So that's kind of a twist to this hypothetical. Normally, if there was no charge for the spectators, and there'd be no sales tax, obviously, if there are no charges for the spectators to watch, then the participants would have to pay sales tax on their participation or entry fee. And that would have to be collected by the Jones family and remitted to the Department of Revenue with their unique sales tax number. And then finally, if for any reason the Jones family is giving away t-shirts, they have to buy the t-shirts and pay sales tax on the purchase of the t-shirts that they give away. If the Jones family is a 501c3 organization, they really have to do the same thing that I just mentioned. So whether you're a 501c3 organization or not, it doesn't matter. The Jones family is acting as a seller, and they must be registered with the Department of Revenue. And that's all I have to say about this particular hypothetical.
Excellent. That's really helpful. Now, again, please note that if we're not advising the Jones family, we wouldn't be advising them in this situation. But going back to Marion's earlier point, at the very beginning, she said, look, we're usually trying to help this client to succeed in making these things happen. So there'd be some sort of, advising of the client to help them understand. And then it's up to them to discuss it with the Jones family. But these are really the Jones family's issues. But we thought it was important for everyone to understand that these issues come up. And sometimes it's our client that's doing these things as opposed to the Jones family. So it's a really good thing to kind of have in the back of your mind. Are there any sales tax issues? And we'll get into that some more. I want to remind everybody that we do have the question and answer. So as we go through these hypotheticals, if you have specific questions that you have about these hypotheticals that you want to ask of our panelists, please go ahead and jump in. All right, I'd now like to turn to our second hypothetical. All right, hypothetical 2. Love Wins, Youth Helpers, and Amazing World are 3 501c3 public charities, and they serve a specific neighborhood in Atlanta. And as part of trying to improve the conditions of that neighborhood, they want to jointly open an after-school program where each of them can provide their services to the neighborhood children. Your client in this case is Love Wins, and they provide counseling services. Youth Helpers provides tutoring services, and Amazing World provides food, clothing, and other necessities for those in need. So it would provide an after-school meal to the children, and we'll have a clothing closet set up, a clothing closet and school supply closet set up for the children. Love Winds is actually located in the neighborhood, and has a large facility that was donated to it. But in that facility, there's a large unused and unfinished area where this after-school program could take place. So they've got the place. So the next thing the three charities need to do is to fundraise, to obtain the grants to build out and pay for the cost of running the facility. The build out will be about $75,000, and it appears that the Joseph Foundation is going to pay for that, which is wonderful. The annual costs are estimated to be about $40,000. And the charity will, each charity will be providing its services using its own funding. So in addition to their own funding that they're going to have for each other, they're also going to need an additional $40,000 to run the facility. You know, there's lights, utilities, all sorts of things. The facility and cleaning, the facility program will need a director, and it was agreed that that person would be an employee of Youth Helpers. The three want to come up with a name and a logo for the facility. So your client, Love Winds, comes to you with a draft of a one-page MOU. They love MOUs, Memorandum of Understanding. They often don't think it's a contract, but it really is. And the other charities don't have any attorneys helping them. So that is our scenario here. So understanding that, I'm going to start with Gail this time and let her jump in with her thoughts on this hypothetical.
So to my mind, this is one, again, that when you get off the call, you're like, your head is spinning. You're like, oh my gosh, there's so much here. But ultimately, there needs to be some sort of an agreement. And if this was in the for-profit world, you'd be thinking, oh, well, we're just going to set up this joint venture or something similar to figure out like who's doing what. And in this nonprofit world, probably it is a memorandum of understanding, which to Robyn's point, everybody thinks is not binding, but it's as binding as the language is, which is something that most people in these arenas miss. But the main thing is to remember your client is Love Winds. That's my client. And so that's whose interest I'm largely representing. The other thing, and referencing back to something Marian said earlier in the presentation, you need to be fair and even, and unlikely that these other two are going to go get their own lawyer. So while you're not advising them, you need to also kind of keep in mind that they are working probably most likely without an attorney. So you want it to be fair and balanced, but you also want to make sure that even if it's something that's on that entity as a responsibility, it will impact your client Love Winds if you don't address it properly. So you need to kind of think through that delicate balance of advocating for your client, taking your client's interest as the main interest, but not overlooking something that, and it may be that you say, hey, you know, to one of the Amazing World, you're Youth Helpers, you're getting ready to hire somebody. You should see if Pro Bono Partnership can help you find an attorney to look out for your interest on this and bring them to the table, because that's a very critical piece of this. And we want to make sure that we don't end up in a situation where Love Winds and Youth Helpers have co-employed somebody because of, you know, the way it all kind of plays out in the end, even though Youth Helpers may be the group paying this individual. But again, so you just kind of have to look at who's responsible for what. And because Love Winds has a lot of responsibilities with regard to the facility in terms of kind of opening up the facility that they've had donated to them and using their space, they're probably going to be the main entity to be on the hook for a lot of this. And then it's just a question of, in a contractual situation, a memorandum of understanding, or whatever you want to call it, just kind of I look at it like a story. It's kind of laying out the story, like the beginning of the story, the middle of the story, and the end of the story. Like, here's who's responsible for what, here's how this is all going to work together. And then ultimately, here's how we all unwind this at the end, if we ever decide to unwind it. If they're going to do any joint fundraising for the, or, you know, if they want to get a logo, again, they're going to need maybe a trademark attorney, depending on how far they want to take this in terms of registering the mark and who's going to own that. There's a lot of things that they've thought of a lot of things. There's a lot of things that come off the decision tree of all of these things as you start laying out kind of the framework for the agreement you're going to put together, that are going to raise a ton more questions, like the logo and the trademark issue. But you know, they're take into account the accounting and who's going to manage this director when they're sitting in the LoveWins facilities, like day to day, who's actually there, who's going to be physically present. I mean, you don't have to put all that necessarily in the contract, but you need to think it through in terms of, if there's a problem with the director, Youth Helpers is going to be the person that has to fire them, but LoveWins is going to be the person having them in their facility every day, potentially, and interacting with people. So there's just so much there with regard to responsibilities and liabilities to work through. And then, you know, maybe Marion can take the logo piece and pick up from there with some of the other issues.
Thanks, thanks, Gail. I think I think this is one of those projects I would not have signed up for based on the volunteer sheet. Like it just makes your head spin. But this is the one that Robyn would call Gail directly and say, "Hey, Gail, we need you to sign up for this one." But
we actually have a few attorneys that do. This is what I would call like a collaboration, right? And we have a sample agreement for this actually that we put together because we've had clients that have done this kind of thing. So we would have actually a form for this. And we do have some lawyers like Gail or a few others that have taken on these kinds of collaboration arrangements.
Well, and I think there are so many issues. I mean, the tax discussion from the first hypothetical was, I think, very revealing. It was, it's a good day for me if I don't have to do any tax at all. So that was just very enlightening. I really have never even thought about that. So it just, a lot of times it does take several attorneys to come together and cover this kind of thing. But I think that, you know, Gail's talking about on this one, a decision tree of sort. I've done some complex ones here where we have a matrix of, you know, here's an issue, you know, here's what the issue is, either pre-launch, post-launch, during operations, and here's who's, you know, taking the responsibility at this point to do it or to write it up. And just to make sure you don't miss something, right? Who's responsible for, you know, what's the deal with the director, and what's the deal with the logo, what's the deal with data and reporting and that kind of thing. So, but just to continue on with the, you know, the thinking through of it. You know, again, our client is the LoveWins, and they do on the building. So if this thing, if they finish out the space, we've got this grant with the Joseph Foundation. If these other relationships don't work out, we've still got this building and the space, and it may be that we want to bring somebody else in. So it seems important to me that LoveWin owns the logo and owns the brand. Not that that we don't want this to work out, but I would like for LoveWin to own it since they own the building. So I'm going to likely suggest that, and there may be a cost of creative or whatever. Maybe we could pick that up. Maybe that could go under the Joseph family funding and own that and let the others use it. So that's one thing to think through. The data issues, I think, can be complicated here because we're going to need to share data. We're going to have to report probably to our grant. Others may have grants, and anytime a grant is involved, you need to ask about, what do they want to know? What do we have to give them to make sure that we're a good steward of that funding? LoveWins, in that they provide mental health counseling, they're going to have different requirements for their data because that's going to be protected by HIPAA. It's got to be locked. It can't all be shared. Some of it maybe can be shared. So we've got to sort through those data issues. Somebody's got to be responsible for releases. We've got these children coming onto the facility, and they're going to be using all three teams of from the different players. So, but there's no reason to make each child's guardians sign-on release. Surely this is something that we could combine on and do one single one to cover liability, to cover photography, to have issues about who gets picked up from from the end of the day and that type of thing. We'll need to think through, are there other third parties that we're all jointly going to need to deal with? Are there transportation? Is there a shuttle bus coming from the school? Are there volunteers that are going to be helping? What other adults on site? What other programming? There's almost always some kind of another nonprofit that wants to come in and provide a program for some, fitness or whatever. So how are we going to manage those? And it seems like this really calls for a pretty disciplined executive committee, executive structure, some decision-making board that can manage these kind of things as they come up on an ongoing basis. And again, thinking about what about an exit strategy? What happens when I don't think that Love Wins is able to exit because we've got this building in place, but we might need to exit one of the other ones, or they may fall apart, or they may merge, and how is all that going to work? And again, I think the executive structure would help with escalation of those issues. That think that the matrix is needs to have an important part about the finances and timeline. How are we going to do marketing, branding? What kind of records? What kind of governance? So Love Wins is going to have some additional issues related to their ownership of the facility, insurance of the facility, paying the utilities, reporting those costs. And I'm thinking that Love Wins, in addition to this overall MOU, they may want a space lease issue with each party directly, because I don't think we need a sublease per se, but I think some kind of usage license. This comes up in so many of these agreements. What can they do in the facility? What can they do with their space? Can they remodel it? Can they paint it? And it's similar issues that you would see in a lease. And what are their responsibilities for damages? And who's responsible? Is Love Wins responsible for the assets that they leave on site, their computers and that type of thing? Who gets keys? Who gets parking rights? So I think a space lease with space license usage with each party is probably a good idea to make sure that they agree to the safety and access requirements, any kind of emergency protocols, and of course the all important insurance requirements.
That's really helpful. And there was a question earlier in the question and answer about whether these are typical hypotheticals. And I will tell you that most of our projects are very straightforward. We have sample agreements or sample materials, and these are much more complex. These do come up, and we have had these, but they're not like our most common projects. So I don't want to scare anybody away from taking on projects with us. But we wanted to make it really interesting and share with you, even these most complex projects can be managed and taken on and addressed. And like I said, we have a sample contract for this. We have a sample license agreement for use of space. And so all these issues can be managed. And in this case, like for instance, where this example comes from, these three nonprofits were pretty sophisticated. They had a sense of what they wanted to do, and they came with a lot of these issues. Not all of them, because that's the incredible benefit of having a Marion or a Gail or Mindy or Richard. But they did have a sense of, okay, we need to work out some of these things, and here's what we're thinking about. So occasionally you get the client that has really not a whole lot. And the reason maybe they came to the table with the one-page MOU was because they had worked it out. Like they had agreed, orally, but it just wasn't really in writing. And then there were some things they hadn't thought about. So just want to share that. Okay, so now I'm actually going to stop sharing my screen momentarily and go back to my panel. And now I've got a few questions because I want to focus on another area of the law, and that is sponsorship structures and agreements. And so I'm going to spend a few minutes talking with Gail and Mindy about those. So I want to start with Mindy. As Associate General Counsel of Emory, you advise on sponsorship structures and agreements all the time. So what are some of the best practices in dealing with these topics? And when do you think a contract is necessary?
Yeah, thanks, Robyn. Good morning, everyone. Well, if you ask the lawyer when they think a contract is necessary, the answer is always. But I do think when you're negotiating and focusing on these sponsorship agreements and structures, that's really important to get into the nitty-gritty. You want to specify when the payments are going to be made, how much they're going to be, in what way they're going to be made. Check, electronic transfer is going to be made with stock. Who is making the payments? Is it an individual? Is it their donor advised fund? Is it their foundation? You want to specify what the benefits the sponsor will receive and be very specific about those. Is it just going to be the use of their name and the acknowledgement of them as a sponsor, or are they going to receive something else? If they're going to receive tickets to whatever you're doing. The people at Emory, people when they're working with Emory, they like to get access to our students for recruiting or something like that. Depending on the type of entity it is, you want to consider including that there's no purchase required in language in the contract. And then of course you want to include trademark and licensing language. So as specific as you can get, I think is really helpful in these types of agreements.
Gail, your thoughts?
Yeah, so I would, having been at Georgia Tech in-house for about 9 years back in the day, and also now having worked with Coca-Cola for 20 years now, wow. I want to point out that there are two different kinds of sponsorships when you're thinking about this space. So there's the kind that the next hypothetical is going to address, which is an event sponsorship, where you as the company are signing up to sponsor a nonprofit's event where they're putting on, a fun run, or an event, a gala like the next one, hypothetical, where they're selling tickets to tables, and what do you get in exchange? And then there's the other kind where you're a sponsor of the organization itself. So in my daily work, I do all the college and university deals for the Coca-Cola company. And so we're a sponsor since we're in Georgia, of the University of Georgia Athletic Department. So if you go to Georgia to a football game and you see all the Coke signage, like that's in a contract somewhere, okay? And so what do we get in return for that? What do we pay for that? That's a whole different and much more involved sponsorship. That, for example, we are a sponsor of the NCAA, and that's a book. That's literally that contract is like this. But as you watch March Madness, you're going to see the advertising for Coke ads in the games. You're going to see all this other stuff, and so that's sponsorship of one kind. And then there's a sponsorship which, to my mind, is a lot more shorter and simpler, but also can be complicated, which is the event sponsorship. But I think as we go through the next hypothetical, we'll go through kind of all the issues that we'll touch on come into play into both of those. One's just more involved and one is less involved. But the other thing I would point out is, depending on having seen it from both sides, I'm super sensitive to things like indemnifications, because when I was at Georgia Tech, we have a research corporation, and most large research universities do, through which we put all of our research contracting. We were always super careful about what contracts we put in place and when, because there's, to Richard's area of expertise, there's unrelated business income tax, also called UBIT, which comes into play. And some of these sponsorship arrangements that you get into, the nonprofit is concerned about, oh, well, this is going to be a UBIT issue for me because I'm taking in money that is not really, directly related to my mission. And so those UBIT issues come into play, and that's a story for another day, but just be aware that the nonprofit may have some concerns about UBIT that might need to be addressed at some level. Again, might bring in a tax attorney for some of that, versus indemnification, where nonprofits can indemnify, but it's especially if you're dealing with a state entity, they really can't indemnify. So your indemnity is to the extent allowed by law. And if it's a nonprofit, they can indemnify, but they don't have open big pockets like everybody. So my response to all of that is to just be super sensitive about if you're coming from the corporate side and working with a nonprofit, you can ask for an indemnity. You can make it as robust as you want. They're going to like basically mark the heck out of it if they have a lawyer on the other side, because they're like, no. But insurance then could be something that you could look at and say like, well, let's just make sure we'll get what we can. We'll make sure everybody's insured enough that we're protected. But part of the dealing with nonprofits sometimes is, as a commercial entity, is just taking on that kind of risk for the good of, you know, the nonprofit world. That I'm okay, this is a nonprofit. I'm not wanting to bankrupt them just because of something happened that I wasn't happy with. And to Marian's earlier point, be fair about the contracting situation and make it so that somebody looked at it and goes, well, this seems fair. Because there are some issues that are unique to nonprofits that, you know, if it was, you know, a giant company versus a giant company, oh yeah, go for it. But if it's not, then be aware that there are some sensitivities on the nonprofit side.
And I'll say, because I am a tax lawyer, I am going to do a little tax primer after Robyn reads the hypothetical, just to give you a little taste of UBTI.
Good.
And understand, if you take on a corporate sponsorship project, there will be someone that can help you with those kinds of things. You don't have to know all the tax information, but it is helpful to get this background because you'll identify the issue. And then you can reach out to your Pbpa attorney and say, hey, I think we have a tax issue here. Can you help? Whether it be sales tax, whether it be income tax, like unrelated business income, or anything like that. The goal is for you to be able to issue spot those things and go back to Pbpa. And of course, we'll be on those initial calls. All right, so now I'm going to share my screen again, if you'll bear with me for a second. Y'all can see my whole screen. Here's hypothetical 2. Let's move on to hypothetical 3. All right, so hypothetical 3. Save the World is holding a large gala event and has a sponsorship package that includes a title sponsor, gold, silver, and bronze sponsors, as well as table sponsors. The title sponsor in this case is Top Wines. It's a new wine store in town, and they're going to give $25,000, but they want the following. They want 10 Instagram posts, 20 tweets, 10 Facebook posts, a TikTok video by Save the World about Top Wines, including highlighting its best wines. In addition, Top Wines wants to be the paid exclusive provider of wine at the event and to talk at the event and share about its latest products and upcoming events. In addition, one of the gold sponsors wants a table at the gala to share information about its products and programming. And then all table sponsors pay $2,000 per table and receive 8 tickets to the gala in return. And each gala ticket is $100. Now, there's a lot of details packed in here, but those are the kinds of details that apply when analyzing the sponsorship arrangements. So Mindy, I'm going to turn it back over to you.
Okay, guys, so I'm going to start out with a brief tax primer, and I will tell you that we could probably spend the rest of the time just talking about a gala and the issues around it. But just to kind of frame this, so as you know, tax-exempt organizations are typically exempt from income tax. The exclusion, one of the exclusions to that is unrelated business taxable income, UBTI. And what UBTI is, it has 3 parts. It's a trade or business that's regularly carried on, and it's not in furtherance of the organization's exempt purpose. So even if the money's used for the organization's exempt purpose, if it's not in furtherance of their exempt purpose, then it can be considered UBTI. So one payment that is exempt from UBTI is a qualified sponsorship payment. And the IRS defines a qualified sponsorship payment as a payment that is made by a person that's engaged in a trade or business where there is no arrangement or expectation that that person will receive a substantial return benefit other than the use or acknowledgement of the name or logo of that company's trade or business. So what is a substantial return benefit? So substantial return benefits are any benefits other than just that use or acknowledgement of the company's name or logo. Anything that is more than 2%, that a benefit that has been given back to the company that is more than 2% of the amount of the payment. So what are some of these benefits, substantial return benefits? So use or acknowledgement is not advertising. So qualitative, quantitative, anything about their products, that's not considered a use or acknowledgement. That wouldn't be considered a substantial return benefit. Exclusive provider arrangements are substantial return benefits. Goods, facilities, services, or other privileges in excess of that 2% threshold are also considered to be the substantial return benefits. So a simple use or acknowledgement of the name, the trademark, however, isn't. And some other things that are not are exclusive sponsorship arrangements as opposed to exclusive provider arrangements. Logos or slogans that don't contain those qualitative or comparative descriptions, a list of the payor's locations, telephone numbers, or internet addresses, and then just value neutral descriptions. So a lot of times with these sponsorship arrangements, what you're trying to do is you're trying to get the payments into this qualified sponsorship arrangement so that it is exempt from unrelated business taxable income. Now, there are other exceptions that we can try to fit it into if it doesn't qualify here, but this is the most common exception. So when Gail was saying that organizations will come in and say, wait a minute, we can't do this because then it'll be taxable income, they're oftentimes trying to fit it into this bucket. Okay, so then starting to work through this hypothetical. So let
me jump in real quick, and that is that we have a webcast on our website that talks all about corporate sponsorships. That was done by two folks at the American Cancer Society, and it's really good and easy to follow, and it walks you through the whole issue. So if you ever take on a corporate sponsorship matter, we have that, and we have an article on it as well. That's kind of the do's and don'ts of corporate sponsorship. So a lot of times if a volunteer takes that on, we send them those materials so that they can really learn what the issues are, and then really they can handle it. It's enough that they can figure it out, and then they can always ask questions of Pbpa if they need to.
All right, so just working through this hypothetical, to me, this all flashes tax issues, right? And so what we thought we'd do is I'd go ahead and take it from the perspective of the charity, and then Gail will take it from the perspective of the donor. So first of all is the what that Save the World wants. So they want to give $25,000, which is great, but they want 10 Instagram posts, 20 tweets, 10 Facebook posts. And the question is, are they doing this? Are they doing it and acknowledging that they're a sponsor of this event? Or are they asking the nonprofit to do this and acknowledge that Save the World is a sponsor, or are they really asking for advertising? And so you want to clarify that, because if they're asking for advertising, that absolutely does not fit into this qualified sponsorship payment bucket and can be considered UBTI. So that's number one. And what we would just want to make sure that we do is that when we're using the name or the logo of the sponsor, that we just use it, we're just acknowledging it, we're just putting their logo up. There's no qualitative, there's no quantitative assessment or information about their products. Okay, so next one is that they want to be the paid exclusive provider of wine. Well, that doesn't get us into the qualified sponsorship payment bucket either. Now, if they want to be the exclusive sponsor, the exclusive sponsor in that industry, that's not a problem. But if they want us to pay them and they want to be the exclusive provider, then that can also be a problem for the qualified sponsorship payments. They also want to talk about the event and share about its latest products and its upcoming events. Again, we don't want them if we want to try to get into this exception, we don't want them advertising at the event, speaking at the event about how great their products are. Having a table displaying their products is not a problem. And you think about like gift bags that you might get if you're running a race and there are all kinds of products in there, that's fine. And that's more of the just the use, just the acknowledgement of the sponsor. But having them actually do kind of an advertisement while they're there, that's a different story. And then tables. So the table sponsor, so they pay $2,000 per table and they receive 8 tickets to the gala in return. And each ticket is $100. That's going to put you over the 2% threshold. And then you have to look and see, okay, well, does the, if you take out that part, is the amount that they're donating, would that be a qualified sponsorship payment? And if the $800 they're donated, is that UBTI or is that something else? So there are a lot of different issues that you want to look through when you're parsing through what it is that they want. And some of these are hard, right? You know, when they're giving you a lot of money, and we'll talk about that certainly in the next hypothetical as well, you know, you want to do more things for them, but you want to, if you want to get into this, this bucket, then you have to be very careful about what it is that you're giving them in return. Gail?
Yeah, so I saw a question in the chat that asked, does it make a difference the amount of money, or is it just the fact that there's a benefit that's received? And the amount of money is irrelevant. It's really just the fact that there's a benefit received. So when I look at this from the top wine's perspective, I'm wanting to get all of this publicity as a sponsor. And so I'm going to throw out my expectations and then I'll let Mindy like correct me on anything that I might not be allowed to have. But to my mind, it's a question of who's doing the advertising. So as a sponsor, as the title sponsor, I'd be wanting, like, if they're advertising the event, I'd want them to say, like, you know, sponsored by Top Wines, which I think is fine. But if I'm asking Save the World to put these Instagram posts promoting my wine products, my best wines, on their Instagram account, I think that's where the line gets drawn, because it's not about the advertising as much as it's about who's doing the advertising. For the same reason, you're not going to go to the baseball field somewhere where Coca-Cola is a sponsor of the team and see, hey, buy this for X 2 for 1, whatever products. That's not the kind of advertising that is going to fit in all these text guidelines. But we are going to see instead, like what you hear on NPR, we're a proud sponsor of so-and-so, so-and-so is a proud sponsor of NPR. They're not hearing, like, go down into this place and buy the baseball cap that we're selling. You're hearing we're a proud sponsor. And that's the reason for those nuances in how that is handled, is because the distinction is who's actually doing the advertising. So I, as the sponsor, am wanting to get the right to associate my brand and my logo with that brand and logo of, and the event of the charity, but I can't ask the charity to go advertise my products for me. So that would be my expectation here. I would want to be the exclusive provider. I wouldn't want anybody else's wine at the event, because if I'm paying to be the sponsor of the event, then I don't want my competitor's wine being served at the event. And so that is a benefit that I'm looking to receive. And then with regard to the table, I'm not sure, well, it says one of the gold sponsors, so somebody other than Top Wine is wanting to share information about the products and programming. I know I've gone to events where, sponsors are allowed to have, a brochure on the table, or, I've been to events where we got free Spanx, gift cards or whatever, because Spanx was a sponsor of the gala. And so that, I think, is allowed. But then the question becomes, what more, if anything, other than that is allowed?
One of the things, and I think Robyn also missed her calling as a law school professor with these hypotheticals that she has drafted. But if you, one of the things that you can read into this too is that one of the gold sponsors wants a table. You need to be consistent. So if you've got your platinum level, your gold level, silver level, you want to have consistent benefits to each of those sponsors too at those different levels.
That's a really good point. So we have had clients who have had these kinds of requests for so many tweets, posts, and so on. And I think one of the things that we've advised is, well, we can't guarantee you this many and this type, but we will, promote you through our social media, for so many weeks around the event, before and after. And it'll be, like Gail said, proud sponsor. Thank you so much to Top Wines. You can have located at, you can have their website. You can describe even what they do. Like if they have specialty wines, you can say they carry specialty wines. You just can't say they're the best new wine store in town, right? You just can't do that. So you can help your client to tailor this to work, to not lose the sponsor, but to hopefully find a middle ground for everyone. On a number of these things. And one of our articles is on corporate sponsorship do's and don'ts. It kind of covers all these details of what we're talking about. So it's right there laid out for you.
I would add that this one seems complicated on its face just because there are multiple parts here. But once you've done one of these are actually quite simple deals to do. Like my daughter's a law student and she's been working with a nonprofit as an extern, and they have her reviewing their event agreements. And in the beginning, she was like, oh my gosh. And now she's like, oh, wow, now I know what to look for. It's not a big deal. It's just super, and they can be complicated, but mostly they're not, because you just start looking for the same things, kind of to Robyn's point with the materials that the pro bono partnership has. Once you've done one, you're like, okay, I got this. This is good. And it's not that difficult.
And with the table sponsor, yeah, agreed. And we have sample contracts as well. We also have, like, if you've got a donor who's giving just $500, you're not going to ask them for a contract likely, but we have sort of an email exchange that you can use to establish that contract. If they're really just giving a small amount and you're just getting their name and logo as a sponsor. So we have some kind of different levels of need that matches with what our clients are looking for with their sponsors. The other thing I'll mention on the table sponsors is, that we also have our donation receipt acknowledgement guide, which would help you when you're getting something back in return. So in this case, they're getting these tickets, the value of these tickets in return, and how to manage that as well. So we can provide you with that. Any other thoughts on this one? All right, so I'm going to stop sharing again because I want to turn to another subject and go back to our panelists. And this is really a question for Mindy, and we're going to now focus on gift acceptance policies and naming rights. And it kind of ties into from the corporate sponsorship moving into this other area. So Mindy, you've been at Emory for 17 years, and this is one of the areas you handle on a regular basis for Emory. What issues and best practices should a nonprofit consider when establishing gift acceptance policies?
Thanks, Robyn. So the biggest issues that a nonprofit should consider are the types of gifts that could be accepted and that they're willing to accept, who has the authority to accept the gifts on behalf of the organization, and then potential conflicts of interest as well. So if I were drafting a policy, I'd really look at, making sure that the people accepting it and the donors also understand that the transfer of cash or other assets needs to be unconditional. The transfer has to be in furtherance of the organization's tax-exempt purposes. The transfer needs to be non-reciprocal, which means there shouldn't be implicit or explicit statement of exchange, purchase of services, provision of exclusive information to the donor in exchange for the gift. You really want to think through, do you want to accept this gift? What if it's not cash and it's not readily liquid? If it's not liquid, are you going to need additional funds to support the gift? Are you getting property? Are you getting a building? What is it that you're going to need to put in place? And do you need to ask them if they're going to be donating a building, for example, and you're going to have to hold it for several years? Do you want to ask them for funds to pay any kind of property taxes that might be owed or any kind of maintenance costs? What type of ownership interest might you have in the asset? Is it a partnership? Is it a house? Is it a building? There are also other nonprofits out there that might be willing to take it and liquidate it for you and transfer the money to you. But you just want to think through all the potential issues. As far as who's donating it, is it a new donor to you? Do you know anything about the donor? Do you want to do an appropriate amount of due diligence? You should do an appropriate amount of due diligence on them, depending on what it is that they're donating. Are they coming to you and saying, hey, we'd like for you to take an interest in this partnership? We'd like for you to take this building. There's going to be some due diligence that you want to do on those. Okay, then so types of those. So number one, the types of gifts. Number two, who can accept the gifts? Is it an officer? Is it the board? Do you want to put that in place? If there are naming rights around it, do you want to have the board accept that? Do you want to have a gift acceptance committee that's made up of certain people that can look at hard gifts or more challenging gifts to see if, is this something that you really want to do? And I used to have a regular conversation with our head of development, do you want to accept these gifts? It's okay to say no sometimes. It's hard. I mean, it's really hard when people are dangling, big assets in front of you or, offering a lot of money. But, sometimes it may not fit with exactly what you're doing or what you need at the time. And then as far as conflicts of interest, just recognizing that you should really should encourage, especially individual donors, to seek the assistance of their personal legal and financial advisors, and that you shouldn't be trying to provide that, that tax or legal advice to them.
What about endowments, including the difference between sort of a quasi-endowment and an endowment where and a full endowment, and what should an attorney be looking for, and when should they be getting additional assistance?
Right. So universities do enter into endowment agreements on a regular basis, and so these are the donor restricted funds where the donor is trying to protect the corpus, so that it will last forever. Some of them do go underwater, but for the most part, they are going to be there in perpetuity. Those are covered by Georgia's version of Pbpa, so there's Georgia law on that. On the other side, and those are an agreement with the donor, or it can be set up in a will or a trust. With quasi-endowments, those are board restricted funds. So it isn't that the donor has entered into a contract of some sort with the organization. It's that the board has decided that they would like to treat money that they've received, eventually money that they've received as an endowed fund, and oftentimes just really to provide some stability by investing those resources and just using the interest or certain payout rather than spending down the whole fund. I think it is, if you're not familiar with these, it's good to get someone who is, just so that you can take a look at Pbpa, understand what you're entering into, understand what the agreements are. I think that there are some nonprofits who are really interested in setting up endowments, but it may not be the right time, right? They don't have the right amount of money necessarily. They don't have the expertise as far as the investment of it, or the resources to go and hire someone to invest it for them. So that's when I do think you want to pull someone in and say, hey, is this the right direction at this time for a nonprofit to set up this quasi-endowment?
That's really helpful.
And Robyn, do you have are there many of your clients who want to set up endowments?
A lot of them want to set up these quasi-endowments. Sometimes they'll have somebody who comes to them that says, hey, we want to set up an endowment. We want it to have this name, and this is how we want you to use it. And so it's really very similar to the kind of university endowments that you set up, only they tend to be a lot smaller. And then, but not always. And then there's a lot of quasi-endowment where a client will come to us and say, hey, we want to start a fund to protect our building, or to help the building become, paid for, where we don't have to worry about covering our utilities and our maintenance and any kind of refurbishment we need to do. And so we want to start putting money away into that so that we can use the investment funds from that and leave the corpus to cover those costs and not have to worry about it. And by the way, we're going to go and do sort of a capital campaign to tell people, we'd like you to give money to this to help us, make sure that we're stable when it comes to these issues. And we don't have an issue where we suddenly need money to replace a roof or something like that.
Yeah, and I think the thing that can get really tricky is if you set up your own quasi-endowment and then you start advertising it and then people are donating into it and then you have a contract with them and you actually have an endowment. Those are the types of things where you really should get someone involved to help you structure that appropriately, especially what you're, advertising and holding out to your donors.
Yeah, okay. All right, so now I want to turn to hypothetical 4. We do have a question. I will raise it. It's a little bit, I think, off the conversation, but let's see where it goes. Does anyone have experience with donor advised funds? Do large companies have a charitable preference for a 501c3? We'll start with Mindy.
Do we have a preference for a 501c3 as far as a donor? Or I'm not sure I understand that part of the question. The problem with donor advised funds is that the person who's donating the money can't contract really on behalf of their donor advised fund. And so what we recommend that you do in an agreement, if someone wants to contribute, is that we say that they can contribute toward the amount that they want to, and that they can, that other entities and organizations can do it sort of on their behalf, so that they can go to their donor advised fund and say, I suggest that you make this contribution to Emory. But there are issues with donor advised funds, particularly with making payments for sponsorships or paying for the entrance fee for a gala or something like that. So donor advised funds can be really tricky when it comes to donations. As far as, what do you think the second part is with 501c3?
Large company question, because I think if you're asking in terms of, does a large company have a purpose to be associated with or donate to a 501c3? I think it depends on what the company's trying to accomplish. Because I know Coca-Cola, for example, we have Special Olympics and Boys and Girls Clubs of America and some of those large national organizations, but that's not necessarily for us to get a donation credit. That's because we want to have a relationship with those organizations for other reasons. In terms of donation, then I'd have to look at what, the foundation does and things like that. I think, again, it boils down to what is the company trying to accomplish. They wouldn't exclude 501c3 or others that aren't 501c3s just because they're not 501c3s, depending on, again, what the end goal is.
I think donor advised funds are a whole separate area that raise a whole lot of other issues. So I think we'll just kind of move on. So I'm going to share my screen again. So y'all will bear with me, and we're going to go to hypothetical 4. Just a moment. All right, so hypothetical 4. Saving Pets is a no-kill shelter in Gwinnett County. For the past year, Saving Pets has had a capital campaign to raise $5 million to build a new building. As part of that campaign, Saving Pets has outlined some naming rights that will go along with significant donations. So, for example, if someone gives $2 million or more, they'll name the building after that donor. And if someone gives $500,000 or more, the play area will be named after them. And it goes all the way down to, if you give $50,000, you can get your name on a kennel. So Betty Black wants to give $2 million and wants the building named after her father, who happens to be a very controversial Politico. In addition, she wants to pay $500,000 now and the rest over 5 years, with the last 2 years being paid in Bitcoin and various stock. Saving Pets is so excited to have this donor, they want to agree to all of it. Then there's another scenario in these different opportunities, and that's Joe Stone, and he agrees to give $50,000 and he wants a kennel named after him. Saving Pets attorneys strongly suggest that they have a contract related to these capital campaign donations and naming rights. Saving Pets says no, it doesn't want to offend its donors. They're just so grateful that these people are willing to donate this money, and really there's no contract needed. And I can't tell you the number of times I've heard that from my clients. 2 years later, Joe is arrested and eventually convicted of murder, and his name is on a kennel. So with that hypothetical, I'm going to turn it back to Mindy to get her thoughts.
So we only have 10 minutes left, and I know we have one more hypothetical. I'm going to zip through this a little bit quickly. But look, you want to have a contract. We all know that as attorneys. I mean, I get pushback too with, more money donated than this. And I say, look, if the donor's willing to donate a lot of money, they're going to be willing to enter into a contract for sure. You want to have the ability to remove the name. It is hard. We get a lot of pushback. I'm sure that others do too. But you want to have the ability to remove the name if something goes wrong. If something goes wrong as far as the person is arrested and convicted of murder or something along those lines, it's helpful to reference a then current policy on naming if you have policies on naming. One of the big things that you should not do is you should not use the name until you receive the complete donation. So and that would be something that you'd want to spell in the contract. So that the one person is donating $500,000 a year, it's over 5 years. You want to make sure that you've received it all or substantially all of it before you change the name and put the name on the building or whatever else. If you don't know the person very well, you want to do due diligence on the person for whom the building space or program is being named, and you want to have all these things in the contract, especially things like what happens when it's renovated, when the building's renovated. How are you going to reflect the initial donor's name? And then again, it's hard, but it's okay to say no sometimes. But I mean, that's as the lawyer, the business people, that's going to be very hard for them to accept.
All right. And then the issue of Bitcoin, you want to address that, or should I briefly? And stop.
Yeah, you go ahead and you can address Bitcoin.
So, when people are willing to pay in sort of various different mechanisms, you need to know the exact price on the day that you're getting it. So with Bitcoin, the price changes dramatically with cryptocurrency. And I mean, literally dramatically. So one day it could be $100, the next day it could be $1,000. And so if you're going to accept Bitcoin, which a lot of nonprofits are now doing, you need to make sure that you sell it immediately and that whatever it's sold for is the value that you're receiving, because you still want to get your full value of that 500,000 in that, or 100,000, or I'm sorry, $1 million in that last 2 years. So the same with the stock. You want to know what the par value is, and you want to make sure it's sold and you get that value. So you need to keep that in mind in the contracting. We do have sample contracts for naming rights, addressing these sorts of issues. And going back to what Mindy said about the renovation 20 years later, do you want to make these permanent names, or do you want to give them the naming rights for a period of time? Because you're going to need another influx of money to do those renovations. Another thing to think about. All right, so now I'm going to stop sharing again. And this time I've got questions for Richard. You've advised many of our Pbpa clients on a variety of sales tax issues over the years. What are some of the triggers that an attorney should look for where sales tax might come into play, where they need to reach back out to Pbpa and say, hey, I think we need a sales tax expert here?
Of late, purchases, especially over the internet from a remote seller, that may not be required to collect the sales tax. That doesn't mean tax isn't due. It's just that the seller did not collect it, and thus the purchaser, that may be a 501c3 organization, has to pay it. Obviously, fundraising events with galas starting to open back up again, and then have silent auctions. There's admissions charges, and that's an issue where sales tax has to be charged or may have to be charged. Certainly with silent auction sales tax is due. Tournaments, you have to collect sales tax on the entry fees. I said before you didn't have to, but that was a specific twist to that baseball, softball tournament where the spectators were being charged sales tax or being charged admissions. That's just a little carve out. In general, for fundraising events, tournaments, galas, silent auctions, there are sales tax issues. And then any sales by the nonprofit to the public, where the public is buying perhaps something over the internet, you have to collect sales tax, typically based on where the product is delivered. Those are three things that kind of pop into my head.
Great. And please, we have that fundraising bulletin that he referred to from the Department of Revenue on our website. I do highly recommend that you look at it. It's got very specific examples of scenarios and what to do and how to handle the sales tax issues for those. So that's a wonderful resource that you have. So now with just a few minutes left, I want to turn to the last hypothetical that we're going to cover. It's Human's Best Friend is a 501c3 that rescues, fosters, and gets dogs adopted. HBF has a physical location with a store in Henry County. It also has an online store and sells items at in-person pet adoption events in Henry, Clayton, and Rockdale counties. The items it sells in all three situations includes leashes, collars, clothing, and water bottles with its logo on it. It also sells a variety of non-logoed pet items such as bowls, brushes, clippers, toys, etc., all through its online store, not at these events. The Human's Best Friend does not collect and remit sales tax on these sales and does not pay income tax on these items. Richard.
Sales tax issues. Well, first of all, I'll call it HBF, Human's Best Friend. They should be registered with the Georgia Department of Revenue through Counsel and through a voluntary disclosure process. They have to do that now because they're sort of past due and they're delinquent. And what a voluntary disclosure can do is it can afford the organization, going, of course, through Counsel anonymously, the opportunity to limit the look back period to 36 months. So anything beyond 36 months kind of gets released and the entity doesn't have to pay the back taxes. For online sales to Georgia customers, HBF should collect sales tax based on the customer's delivery address. Of course, I can't reiterate that enough. For on-site sales, live sales, HBF should collect sales tax based on where the customer takes possession of the product. So if it's in Henry County and they get the product there, they have to collect the Henry County tax.
So to back up for a second, they need to be collecting and remitting sales tax on all of these items that they're selling because it's tangible personal property.
Correct.
Unless they're selling it out of state to someone in another state, and they don't do that very often. But otherwise, if they're mostly, and in this case, they're mostly selling to Georgia. So in this case, because it's in Georgia, they have to do this. And it depends on where the person's located who's getting the goods. Is that what I'm hearing?
That's correct. And just keep in mind, you can't just say, oh, we're a nonprofit. We don't have to worry about collecting sales tax or paying sales tax or do anything with sales tax. We're a nonprofit. If that were in any question or in any doubt in the past, that was all clarified with the 2020 bulletin that, Robyn, we worked very hard to get put together and that you did at the request of the then Revenue Commissioner. So they're going to be enforcing this, and they have enforced this. And nonprofits need to get on board and understand that. Enough said.
So now, in addition, there's an income tax item, and we're running out of time, but I want to turn quickly to Mindy to talk about the income tax issue.
Right. So again, we talked about UBTI before and what that is. There's some exceptions to UBTI. Now, I'm assuming that these items have not been donated. I'm assuming that they're not primarily sold by volunteers, because if either of those is the case, then there is an exception to UBTI. But if they're just items and you just have a store and you're just selling them at retail, then for the logoed items, there have been rulings that logoed items do not generate UBTI because they create awareness of the exempt purpose of the organization. They're educating about the organization. For the other items that are not subject to the logo, if they don't fit into another exception, then those would be subject to unrelated business income tax, and you'd have to remit taxes on those.
Because basically, you're selling things that you can get at a pet store.
That's right. You're competing against for-profit businesses.
Yeah. Okay. Well, we've made it through 5 of our 6 hypotheticals. I am so grateful, and I'm going to stop sharing for a second. I am so grateful to my panelists. You guys are rock stars. And I hope you all have learned a great deal about sort of some of the complex issues that we deal with, but understanding that we have lots of resources for you. And this was really just to help you think through how to manage contracts, how to address some of these issues that you may find yourself with, and to know that we are here to help you with any project. So we really hope you'll go to our website and sign up and begin to take on matters with us. And with that, that concludes our presentation, and we are right at the 11 o'clock mark. So thank you all very much and have a great day.
Thank you.